Hello, hello, hello.
Mute. Joe, you hearing me?
I hear you, man.
Cool, man. Yeah, all right. That sounds like a good idea. I'm going to go grab that quick cup of coffee, too. I'll be right back.
Morning, everybody. We're going to give the stragglers this Sunday a little more time to come in. There's usually a few. There's Marie. All right.
Hi, good morning.
Good morning. So this is going to be one of our most important videos because I think a lot of you, or webinars, because I think a lot of you who are, now that you've gone through the process, and there have been a lot of form fills, there have been a lot of duplicate form fills, which is okay because a lot of times those duplicate form fills are made for the purpose of correction. And I've been able to take those corrections, incorporate those into the AI, spit out new sworn statements, and I'm going to distribute this video like I have every other, because a lot of people who are not here today are going to benefit from what we're going to talk about today. Because there's a lot of, I'm not, it's not intentional, but it's just sort of the nature of the beast when you're suing the federal government. That is confusing, and that is, I think some of that is intentional, but it's also sort of an accidental byproduct of what the government usually enjoys, which is with a doctrine known as sovereign immunity. It's a throwback to jolly old England, where you can't sue. The idea is you can't sue the king in his own court. Right. So and that's one of the few remnants. Now you won't find it in the Constitution. You won't find anywhere in the Constitution that says you can't sue the United States government. But it's a common law doctrine that's carried over from England that says basically the United States government, or all sovereigns, basically enjoy immunity from suit from their constituents, unless Congress specifically waives that immunity. That is one of the things that we were fighting about back in almost exactly 2 years ago. Yesterday is when we got our remand back from the Court of Appeals. So, for those of you who have, I don't see any new names, but if, not risking it on my memory. For anybody who has not been to one of these meetings before, my name is Joe Witcomb. We've held dozens of these, I think now. I'm lead counsel on the case against the United States government. In the most general terms, it's the case against the United States government for its employment practices. And we have always been, since Jason Lambro joins us today. I don't see Mr. Jordan. I do see Miss Justice. Justice is here. She's one of the other main plaintiffs. That is one of the other conversations that I'm going to have with you guys today. But I want to kind of explain what we've gone through for the last couple of weeks, right? So I sent out a form back in late April. We now have, as of this morning, 331 unique form fills. Now, when I deduplicate that list, there are 250 individuals who have filled out the form. That is extraordinary, because we only had, as of this time last year, maybe August of last year, we only had a total of 280 people in the case of any variety. We only had 280. Now we have 250 folks who've actually filled out a form. Many of you, 81 of you to be exact, have filled out a form more than once. Some of you have filled out a form more than once because, again, picking on Jason, I think
filled it out 3 times, honestly.
Right. Jason is one. Jason and a few others. I know Tracy was in this group a while ago, but they work for more than one agency over time. And this suit is not, while the Voice of America is an agency, it's certainly not the only agency. So I want to catch you guys up on what's happened. So almost, first of all, I'm sure everybody on this call has received and signed a sworn statement and Form 95 and an engagement letter. Now, Some of you signed new engagement letters for the FTCA action, Federal Tort Claims Act action, and you will not fit into that action. But your time was not wasted because I got the information I needed from you to add merit to the FLSA action over to Court of Federal Claims, which is currently filed. So I know that's a mouthful and a lot of acronyms, so I'm going to go over it this morning for everyone's benefit. And I'm going to post this to YouTube, and I'm going to add it to our website so that it makes sense. So I started our conversation this morning by talking about the issue of governmental immunity. And I'm not trying to bog you guys down with a law school class, but understand what that means is you can't sue the government unless the government through Congress says you can in a specific instance. The specific instance in which we started this case was under the Fair Labor Standards Act. That was styled primarily, or at least initially, as against Voice of America. Now, we raised the issue in that case because Jason was our primary plaintiff on that. And then we picked up a bunch of new plaintiffs in 2024 and so forth. But the idea there was we pled this issue of misclassification because it was the only way that I could demonstrate to the court that Jason and those like him, those misclassified 1099s, were actually entitled to overtime and minimum wage. Jason, I'm going to mute you, okay, bud? So we can't
Go right ahead.
Yeah. So this is why we pled the issue of misclassification. But the damages are actually the unpaid overtime and unpaid minimum wage as it relates to the Fair Labor Standards Act. Now, some people will immediately say, well, a lot of you have said, I wasn't shorted overtime. Some of you will need to go back and review your contracts because many of your contracts, maybe even unbeknownst to you, had a provision in that contract that said that you were on call while you were 1099. You were on call 24/7. It specifically stated in a few of the contracts that I've read that you had to come in. You had to be ready to come in at a moment's notice. And it may have happened experientially. It may have happened if you were in the news universe and some big story dropped and you had to drop what you were doing and come into the office. That on-call time is required to be compensated. And I don't think anybody was compensated for the on-call time. The other thing was people say, well, whenever I was paid, I was always paid at least minimum wage. The difficulty there is for the individuals who did work for which they were not paid at all. Now, the way that happened is that many of you had your income, your invoices suppressed by virtue of a contract clause that said you were only allowed to invoice up to a certain amount of money. Now, for everyone else, for a lot of folks who were PSCs, or W-2s, right? You were shorted overtime in that instance. And many of you were shorted overtime as W-2s, even when you became PSCs, whether you transferred over as PSCs or whether you were hired as PSCs. You were shorted overtime in those cases because many of you were forced to work over 40 hours in 1 week and then asked to take time off the next week. And you were paid regular time for the time that you took time off. The difficulty there, why that isn't adequate compensation is because it does not give you the time and a half. It just matches time for time. Overtime requires time and a half for the hours that you worked in excess of 40 in a particular week. And that includes time that you were on call, even if you didn't work, for which you were not paid. Or if you were called into a meeting, or if you were given a bunch of things to do as far as maybe a lot of you, if you were in many of you will say, well, I wasn't forced to work overtime, but I did. That is still compensable time. So if you were, I don't know enough about what you guys do for a living, so I'm going to sound like an idiot here for a second. But say you were an editor and you were doing work outside of the office to get us a story ready, or you were doing something, you were in video and you were editing video after the story was done, after your workday was done. That is still overtime, or that is still time for which you should have been compensated either at regular time or overtime based on the fact that you were whether you were under or over 40 hours. Now, pivoting over to some of the, like a bunch of you. So yet one thing I want to tell the whole group that you don't know yet is on Thursday, I FedExed, I think it was 95 or 96 of these standard form 95s. There were 4.5 pounds of these forms that went to VOA, and about a little better than half of that went to the Social Security Administration, because virtually everybody who worked for the Social Security Administration was misclassified. About over half of the folks who worked for VOA were misclassified. A much bigger number than we've ever had before have come into this case who were W-2s. They were PSCs the whole time. And those folks have maybe thought incorrectly, and maybe the court has taught them incorrectly, that they weren't eligible for the case. But they were, because even though they were PSCs, they were still deprived minimum wage and overtime. Now, as far as the Federal Tort Claims Act case, that's another statute under which the government has made itself vulnerable to suit. That is based on state law. And that's what I've tried to explain. And I don't know if I've done a great job of it, but that's based on state law. So let's take, like I said, you take Jason, who lives in Maryland. Maryland has laws that say employers may not misclassify their employees, and those who do are liable for damages that they've created through the misclassification, having nothing to do with, certainly having to do with minimum wage and overtime, but not exclusively minimum wage and overtime, having also to do with things like the other fringe benefits that you would have enjoyed had you been a W-2, had you been properly classified as a W-2 employee.
Like workman's comp.
What's that? Yeah. So things like, if you were an employee and you would have had parking paid for, that's a thing. Many of you who work for the Social Security Administration, I've heard from, have said they had a huge amount of uncompensated mileage that they were driving back and forth to hearings, and they would turn in invoices for mileage and never get paid, or it just so happened that particular hearing office didn't pay for mileage. Or you would show up as, I know Sue shared this story with me, you'd show up and spend the entire day. And this is something I just recently learned, I think a couple of weeks ago from you guys. Many of you would show, there was another clause in the contract that said you couldn't get paid for more than $25 in canceled hearings, irrespective of how long you were there for the day, right? So that would fall under both uncompensated overtime and potentially a violation of the minimum wage statute. But also because you should have been properly classified as W-2s, then that creates another liability for the government, because now you were deprived of things like your 7.65, which is you paid self-employment tax on money you shouldn't have paid self-employment tax on. You had uncompensated expenses that you didn't get paid for, that you would have gotten paid for had you been an employee. So these are all things that are incorporated. And this is where you guys all got to see the damages model that the AI unpacked for. Now, the AI, if you should all know this, was extremely well informed. I pulled in literally 1,200 different documents to inform the AI on the law and the rights that you all were entitled to, right? So all of those forms, almost all of those forms, there's probably about another 30 95s and sworn statements. Some of you that, I don't know that any of you that are on this call are necessarily part of them, but there's a few for which just technically the Dropbox sign didn't make it into your inbox, or we're using another software called PandaDocs. We're going to get some forms out to you that way. That gives us an additional way to send things through text. So Dropbox doesn't allow me to send it to your cell phone on a text, but Panda allows me to send it to your email and to your cell phone, so that you'll definitely get it. I was even able to get some of the folks who were working overseas those forms. But now you're going to get, you should all hear me say this, you're all going to get or many of you are going to get a new round of, say, documents. It's just one document, right? So you all completed a sworn statement specific to the state-based Federal Tort Claims Act case. That's the state law case. Some of you, again, will not fit into that state law case. You will almost all, 99% of you, there was just a very small number of people, in single digits, could count on one hand, that said, I was never shorted overtime. I never worked a minute for which I wasn't paid. I was never misclassified as anything other than a W-2, that, those people will probably not fit into any of our case, and except for the one other element for which you will fit in is a retaliation claim for those of you who were fired in March and May of 2025, and that's also included in our case. So what you're going to have coming in an email, maybe starting today, but definitely this week, if not today, because I've already generated a bunch and I can generate these pretty quickly. It's all based on the same information in the forms that you've already completed. There's no more forms to complete. All you're going to be doing is fixing your signature. Some of you have updated your forms. Many of you have sent me emails and say, hey, Joe, I got this fact wrong, that fact wrong. We've corrected all that stuff. I actually made the corrections in the form that you completed, so I could pull that form into the AI without having to and make sure I got a comprehensive picture of your story. So I'm going to be sending sworn statements out that are specific this time. Instead of the state-based claims, these sworn statements are going to go into the existing case that's been open since 21 and 24, right? Now that case also has that Court of Federal Claims case. That's where in my mind, the government has the biggest vulnerability because they've already lost on an appeal. They're about to lose again on another appeal as it relates to the equitable tolling issue. I've got a reply brief due on that case, not this coming Wednesday, but the following Wednesday. And then that appeal is fully briefed and we'll be waiting on oral argument, which should happen. I'm expecting that to happen sometime in the fall or winter of 26, maybe early 27, and then a decision to follow. And if that goes the way I fully expect it to, then that's going to open up the backward-looking damages picture a great deal. So for some of you, like picking on Jason and Sue again, who worked for your respective agencies for 15, 20, 25 years, that's going to pick up, if I'm right, and I think I am, that's going to pick up damages going back a lot further. And the damages model that I've created for you, like for Jason, I created 3, and for Sue, I created stuff going all the way back. That damages model should be reflective of the amount of money that we are hoping to get from the government based on the full time that you work there. So that's what's going to be happening in the very near term. So again, the new document that you'll be seeing is just a restatement. It should be almost a verbatim restatement. There'll be some of that FTCA stuff that's not in there, but it should be a verbatim, maybe slightly shorter restatement of the sworn statement that you've already signed. There'll be one signature, no more engagement letters to look at or anything like that, just that signature. And then I'm going to get those filed in the Court of Federal Claims case that's already been existing and been going for a while. And then that leads us to the very last thing I plan to talk about today, which is I'm going to file an amended complaint in that case, because when Judge Summers ruled against us on summary or on the government's motion again back in December, he dismissed my VOA people, he dismissed my USPS person, he dismissed a lot of those folks. He dismissed, and now all we've got is just the justices from the rest of the Social Security litigants. Now, what I'm going to do in this amended complaint, because there's been no discovery on this case, we haven't blown any deadlines, is I'm going to, based on these new completed sworn statements, I'm going to amend the complaint to add a bunch of W-2s, a bunch of 1099 VOA people, a bunch more social. Well, I don't want to add a bunch. I want to add probably 10 or 12 new people. 10 or 12 new people to the named complaint. Now, I'm going to send out an email today, and I'm going to ask for volunteers. I definitely don't want to make anybody a named plaintiff who doesn't want to be a named plaintiff. What I'm looking for in the named plaintiffs are people who have suffered damages after 2021, July of 2021, with their respective agencies. In other words, you've been shorted overtime or minimum wage. I don't care if you're W-2 or PSC. I'm going to add you folks I want to add whoever volunteers to the amended complaint. Now, if we go, it's basically the reason I'm doing this is it's a hedge, right? I fully expect us to win on appeal on all of the issues that I've raised on appeal. But this hedge is just to hedge us against the event if the Court of Appeals doesn't rule the way I'm expecting it to. Now, I fully expect it to because, again, we're a case of first impression. We've already been remanded from the Court of Appeals once on this case. There's going to be some eyeballs on this. It's got a lot of attention already. And so what I want to do though is make sure that we have, and also want to start discovery. So I want to add some VOA, some Social Security. We've already got enough Social Security people to do discovery if we needed to, but if I add a few more, it won't hurt us. Get some more VOA people. Marie, interestingly, I got an email from another USPS person this week. Yeah, but now it's a little bit convoluted. I have to talk to them. I have them on my calendar this week. It looks like they work for somebody that was doing what you're doing, and they're complaining that they weren't paid. What I expect is true is like in your case, the Postal Service just shorted the contractor money, which like the Carmazzi and the ACE incident, right? It ended up shorting the subcontractor because the contractor didn't have enough money to pay the subcontractor. So that I'm going to talk to that person, but that would be another human that I could add to the USPS claim. So all of that, so what I'm really trying to do, ladies and gentlemen, we've been 2 years back from and because Summers has been just, sort of slow walking this thing, we haven't gotten to do any discovery. So I want to get that started, which is why I'm going to amend the complaint. I've said a lot of words, and I know that I probably have talked about half the time. I've probably created some questions. Jason's hand's up. Let's go ahead and start with him. If you got a question, do your hand raise. You guys know how this works. And also I'll go Jason and then Rochelle. You tell me if I'm saying your name right, if it's Rochelle or Raquel, but we'll get to you. Yeah, Jason, go ahead.
Copy that. So 2 quick questions. We're getting into discovery finally, correct?
So we had an order come back that on your case specifically, the courts opened up discovery as of Friday. We have a discovery deadline in 6 months from now. But that's fine. Yeah, I'm going to do discovery for you, but that's because of the way Judge Summers handled that case, that's related to you specifically. In the Jordan case, I'm trying to add to the Jordan case so that we can get into discovery about the number of plaintiffs and that stuff going on right now. Oh, and by the way, the government motioned to stay the Jordan case on the basis that they want to have DOL wants to do an investigation. They originally said against Carmazzi and Ace. Then they came back and said, well, no, the DOL said we're not going to do an investigation because they've already did it. They already did the investigation and they've already settled with Ace and Carmazzi. So not Carmazzi. They didn't settle with Carmazzi. They settled with Stratcom.
Gotcha.
So there's no there for the government, but the government has engaged in one tactic alone. Their only tactic the government is involved in is foot dragging, period. They're just sandbagging because what they're hoping, ladies and gentlemen, why I keep having these meetings with you guys so that we keep touching base is because the government is just trying to wear you out. I don't think they have any hope or faith that they're going to wear me out, but they have hope that they can maybe make you guys become disillusioned and, want to go away. Jason, what was your other question since you were already with you?
Thanks. So do we have a Court of Appeals date yet?
So the Court of the reply brief, I said this a second ago, the reply brief on the Court of Appeals is due, call it 10 days from today. It's due a week from this coming Wednesday. Once that reply brief is filed, that is then what we lawyers say is it's fully briefed. It's in the courts, pardon the tennis pun here, but it's in the court at that point. Now the next thing the court will do, this Court of Appeals in virtually every instance, not all courts of appeals do this, but the Court of Appeals for the Federal Circuit invariably schedules oral argument. So that'll mean, what you've seen me do more than once. So I'll fly into DC, I'll go to that court on from the Capitol and do the oral argument. That's like a 4-hour round trip for me to argue for 15 to 30 minutes. But that's what happened for
do it so well.
Yeah, that's what happened for your case in December of 23. And I expect a similar. I expect a better outcome because this one is not a close call. This is an instance where the court decided basically things that could only be decided on an evidentiary basis. He decided on the law on a motion to dismiss. So I think that's going to get.
Is it going to be Summers again or no?
Well, well, look, the Court of Appeals has the authority to say, like, hey, Summers, this is your second at bat. You screwed up. And what that would look like is the Court of Appeals, if they remanded it, they could remove. They would be remand and remove. So if the three R's, I call it, reverse, remand, and remove. So if you guys want to incorporate anything into your daily meditation mantras, put the three R's in there: reverse, remand, and remove. Reverse means take everything Summer says is reversed, just like it sounds. Remand is sending it back to the trial court. Removing is telling the chief judge at the Court of Federal Claims to reassign the case to another
That just be so nice.
Yeah. So if you guys are incorporating anything in your thoughtfulness, or your mindfulness, or whatever, reverse, remand, remove, the three R's.
The Court of Appeals would not have Summers in it, correct?
Yeah, that's right. If it gets removed, it would go to another judge who would hopefully have more. That Summers, apart from being just cranky, but he also doesn't have. He's already admitted on the record he doesn't have a depth of knowledge in employment law. He's never practiced in employment law. So there is when we refiled the new Jordan case, it went to a judge who had an extraordinary depth of employment law, and then Summers lobbied for the case to get it back into his docket, which is obnoxious. Anyway, going to next was Rochelle had her hand up.
Hello, if Rochelle is correct, we're saying it
Rochelle,
correct.
okay, thank you.
So, two questions. Now, did I hear? I want to verify. Everyone you will be sending new sworn documents to be signed from everyone. Is that what I heard?
Yeah, yes, ma'am. It'll be essentially what you've already signed. The only difference you'll see when you look at it will be the heading, because the heading will be, instead of being aimed for a federal agency on a federal torts claims side, it'll be styled. It'll have a heading for the Court of Federal Claims. It'll have the case number on it for the Court of Federal Claims case. But the narrative, the stuff that you've already essentially signed, should read essentially identically. It may not. It may be a little bit shorter, because the stuff that we're focused on at the Court of Federal Claims is just related to, some of it'll be related to misclassification, because that's how we get you eligible for the overtime and a minimum wage. But if you were properly classified as a W-2, it'll just talk about the minimum wage and the overtime language there. Okay.
And the second question is it too late for someone else to join the case?
Not at all.
Okay.
In fact, well, I thank you for asking that question, Michelle, because one of the really cool side effects and fringe benefits of this case, that I'm going to geek out on you guys a little bit, but we've probably added, some of you, I don't know if you're on this call or not, but some of you who will be getting this email, listening to this video, some of you are getting engagement letters for the Court of Federal Claims case for the first time, because you just added to this case. So that's a super important and timely question, which is this: if you know of anybody that was harmed by the government's employment practices on things that we've talked about week after week, get them to fill out this new form, because I can use that form. If you guys have got it in your email, you can forward it to them. They can fill it out, and it'll go in. And it's a running total. I can show you guys right now. There's 331 of these forms that were filled a week ago. Last weekend there was 309, and I've had to create new cases, which is a hardship I'm happy to endure. I've had to create new cases inside of my case management software and send new engagement letters to people who've never been in this case before, which is outstanding news. Listen, when this is all done, my expectation is that there will probably be, just to go back in time a little bit, when the VOA was involved, when the OIG, Office of Inspector General, from the State Department, was investigating VOA back in 2013. VOA, I'm quoting from the investigators. The OIG said, hey, we think there are 660 folks that are misclassified and have not been paid. This is the Office of Inspector General, have been misclassified and not paid overtime. Right now, I've got maybe 150 VOA people. But that's not the interesting part. The interesting part was VOA's response. VOA's response was, we've had thousands of contracts. There are thousands of people inside of VOA that the government has either misclassified, mistreated, and they've gone to trouble to mask their identities because there's a public facing website called usaspending.gov. And if I have a contract with the government to sell them paper towels, that my paper towel sale is listed on USA Spending and how much money they bought from me, except unless it is below the micro purchase threshold. Now, many of you who've read the contract, will, like Jason's, I've read, it says you may not invoice us for more than $3,500 or the micro purchase, which happened to be at the time the micro purchase threshold. And the reason they were having people bill at lower under the micro purchase threshold was so that they did not have to report it. So they were hiding how much they were spending, so they didn't have to report it. So it looked like they were just, but what they ended up doing is reporting. There's a few thousand entries when I pulled that data that said unknown foreign contractors, which is basically in my mind code for Chinese, Russian, Persian services, all the different foreign services that were inside the BOA. Rachel, did I answer your question intelligently? Did you get?
Yeah, so I could just forward this last email you sent to someone if I think I know.
Yes, God, yeah, from your lips to God's ears. Just as many people as we get in here, that gives us, because again, I'm going to keep filling out Form 95s. I'm going to keep sending that stuff out. I'm going to run up my FedEx bill. I don't care, because that's a way to get this stuff. Because now I have proof that on Friday, the 12th, they received 95 one day. All right, somebody's echoing on me, so I'm gonna have to. All right, so, all right, now I think, and next in line was Ruzba. Tell me if I'm saying your name right, Ruzba. You're still muted.
Some of my friends, we talked about the affection of the separation or dividing these forms after you sent for us. Is there any affection on the claim that you wrote for us before and we signed it or not?
So I think you're asking me, has there been any movement on the claims that you've signed and sent to me, right?
Yes, because all of us, not just me, as I mentioned, we are W2 PSCs.
Yep, those so you guys are what I'm doing with your cases is I'm taking that sworn statement and filing it in the existing Court of Federal Claims case. And I believe you've been in the case. I'm going to look right now, but I believe you specifically have been in the case at least since last year.
Yes. So there is no any affection on the amount of the claim.
No. So if there were, let's say there were furs, as an example, right? As one example of things that so what we don't know yet is whether or not the government exceeded its authority. This is another really nuanced, tricky issue. There's a theory that the government exceeded its authority on the PSCs. In other words, they may have added more PSCs than they were allowed to add to the PSCs. But at the end of the day, if they properly classified you as a W-2, then the bulk of most of your claims that were missing, the bulk of those claims were in unpaid overtime and unpaid minimum wage. Time that you worked and you were not paid at all, or time that you worked in excess of 40 hours for which you were not paid time and a half. So the bulk of that claim should not go away at all. Now, if there's a state-based claim for misclassification, some of those damages may go away by virtue of the fact that you weren't misclassified, right? Only if you were misclassified would you be entitled to the state-based claim of misclassification. Now, I've got the information. If I learned that they violated some other state-based claim, right, unrelated to misclassification, I could still use that information. If something in your file showed that they violated some other state statute, right, some other state laws, then I could still use that document that you completed to go after the damages on those state-based claims.
Yes. Thank you. Thank you so much.
Of course. Ignatius.
Hi, Joe. Good morning. Can you hear me?
Good morning. Good morning. I can hear you great.
Good. So I just wanted to say that I responded to an email you sent me last week regarding the form that she asked us to sign, but nobody has gotten back to me as yet.
Let
So
me,
he will
I'm at my desk
do
right
that.
now. Let me make sure I'm not missing something, because I get about 250 emails a day. If one really great way, all right. All right, so what I can do, I'm looking at this email, looks like it came out on 6/10. I can take that, and it looks unread, so it got by me, English. That it's showing here as unread. So it just got into 250 plus claims that, or 250 plus emails that hit my inbox every day and just got by me. So what I can do is take this information that you sent me, add it to the form that you've already created, have the software generate a new sworn statement, and send that to you. And if I've already mailed your sworn statement, and there's a chance that I have, I can just what'll happen is the government will send me back a form, right? That's in it, and I have 6 months to amend your claims if there's any changes to them, right? So if they send me back, they'll send me a form that says, "Hey, we got Ignatius' claim, and it's for this amount of money, and we received it," and they should say we received it on June 12th, 2026. And they'll say the letter that they send me snail mail will read, "Your point of contact for this claim is, Johnny Snuffleupagus at voa.gov," right? I can then, because I've opened the claim, I can send supporting information and updates to your claim that way. Does that make sense? I can send a new sworn statement, a new affidavit to update your damages calculation.
It does. It does. It does. Thank you.
Okay, perfect. All right. Devrim.
Yeah, hi Joe.
I
Hi
hope I'm saying your
everyone.
name correctly. I hope I
Yes,
didn't.
you are. Thanks. So you might remember we corresponded a couple of times last week.
Yes. Yep.
And I had also sent you an email, but you might have missed it because I'm sure they were getting like hundreds of emails a day.
6/11. I've got it right here.
Okay,
6/11.
so last week's, I think it's Thursday, probably
Yep.
Thursday. I
Yep.
shot you an email. So anyway, so I was both a 1099 and a W-2 with VOA.
Right here.
And so you had sent me the misclassification form again so that I would fill it out once more. But the problem with that form is that
You can only click one at a time. There was a box on there that said option 2, which I should have been clearer about what you could have done on option 2. But here's what I will tell you. And everyone, I don't mean to cut you off, but I'm reading your email right now, and here's what a lot of people, and yourself included, have done. If you can give me as big or as long as a narrative as you want, right? So you could send me a narrative in an email like you just did that says, from this date to this date, I was a 1099. From this date to this date, I was a W-2, right? What I would tell anybody is, if at any time you were ever classified as a 1099, click the 1099 form. A bunch of you have also filled out multiple forms. So a few of you have filled out multiple forms because you work for different agencies, but it'd be just as good of an excuse to fill out multiple forms if for one period of time you were 1099, you have one form for that, and another period of time you were W-2. But you could go to that trouble, or you could do what you've done here in an email. Send me an email that says, "Joe, from this period to this period, I worked for this, I worked as a 1099. From this period to this period, I worked as a W-2." And as specific as you can be. Now, listen, it's not, I don't want to put too much of a problem, like too much of a burden on you. To the degree that you remember, and you can say, during this period of time, I worked an average of 5 hours a week overtime. And I remember why. Like, we were working on this. One person wrote me an email or wrote me a narrative that said, during this period of time, we were working on, I think, like a presidential election. That was one thing I see come up more than once, right? Presidential election, it's all hands on deck. Everybody's working ridiculous, obscene hours. Might be working, 60, 70, 80 hours in a week, basically round the clock coverage for this particular, political event. Or maybe when the war kicked off in Iran, or when something else happened, something important, the war with Hamas, whatever it happens to be. That makes it super credible, and it connects it to a time. So it's like, during this period of time, I worked 80 hours a week. on average, I work 5 hours a week overtime. Anything you can incorporate, because what I need everyone within the sound of my voice to hear me say is this. It is not our job at this stage to prove anything. A lot of you have written me and said, well, I don't have any records to prove this or that. Not important. What's important now is for you to memorialize as much as you remember that I will then turn around and use to verify through discovery. And I've said this almost every call we've had, but it bears repeating, which is this. It was on any employer, whether it's the United States government or the Dairy Queen down the street, it's the employer's responsibility to track the time of the employees that work for it. Now it can, now if it provides a clock in, clock out system and you don't use it, well, then they have a defense that I gave them a way to clock in and clock out so you can use it. We know with absolute certainty that VOA didn't do that. We know that the only thing they allowed you to do was submit an invoice. And they're trying to do this because Jason's state case has moved a little further. They're trying to say, well, Jason only submitted invoices for this amount of money. And my response is simple. That's because your contract only allowed him to submit invoices. It said, irrespective of how much you work, don't invoice us more than $3,500 a month. That is not your fault, and it's not your problem. That is the government's fault. That's government's problem. And because the chorus of you, like maybe Jason would lie or Devreem would lie, but there's no one with a straight face thinks that 250 people are all telling the same lie. Nobody thinks that. So if we get, the more folks we get that are telling the same story, the more credible you look, because you guys are being specific. You guys aren't just saying, hey, well, I worked 5 hours of overtime. You're saying why. I worked 5 hours of overtime. Here's why I worked. Or I worked consistently 5 hours. Some people were so specific. They were telling me they made me clock in and out for lunch, but I didn't get to take lunch. That's a half an hour a day. That's 2.5 hours of overtime a week for which I didn't get paid. Or they made me come in at 8 o'clock and do a meeting for which we weren't allowed to clock in and do that. So that's 5 hours a week of overtime or whatever it looks like. I don't have to prove anything. I just have to make a straight-faced allegation. Now, if somebody came in and said, a few of you had to go in and correct your forms because you would say, I worked an average of 40 hours a week overtime. I'm like, well, that's probably a typo, right? That's probably, and I would write you. I didn't do it unilaterally, but I'd write somebody and say, hey, you put in here that you worked 40 hours a week of overtime. Some of it's going to be language barriers. That's stuff I'm okay with, right? It's just, but it's just, we go in and we make it as correct as we can make it now. Our job to prove it up will come later, right? Because they're going to put, eventually, they're going to come at me and say, well, look, they gave these invoices. I'll just point to the contract and say, well, look, that's all the contract will allow them to do. You can't fault them for following the contract because, again, for many of the people in this case, not everybody on this call, but for many of the people in this case, they were operating on this contract under threat of deportation if they got fired. And many of the people that are connecting with me now are connecting with me from their home of origin, their nation, their country of origin, because they had to go home when they were terminated in May of 2025. So, did I do a good job answering your question, or did I leave more out? I guess I want, in a short way, I just want to say, if there's any information that you think is outstanding, right, then just put it in an email to me. I'll incorporate it into a new sworn statement, and I'll send it to you very quickly and easily.
Okay, so just one more thing. There was some correspondence with some of our fellow PSCs last week, and they were also saying that the form, the specific form, the misclassification form, where we have the section 2, it says, how were you paid for your services?
Yep.
And some people that I know, they were both, like myself, we were both W-2 employees and 1099s, and we were paid via a third-party contracting firm, which was Netcom and Starhawk. But on this form, my question was specific to this form. So there's no way for us to click on all three. We have to just choose one. Sure. Was there like a glitch with the form, or like in my case?
You're talking to the glitch. I'm the glitch. I'm the guy who created the form. I should have, and I can go back and do this again. Now, I tried to create, what I tried to do is in section 4 and section 5 of the form, I left you like a free narrative where you could put in as much, and there's no limit on it. You could put as much in there as you want, right? And the AI will pick up on anything. So if you click W-2, but then you put in that narrative, hey, by the way, I worked as a W-2 from 2015 to, or I worked as a 10, a lot. This is the story of a lot of folks I hear. I worked as a 1099 from when I started with VOA in 2015 until they converted everybody to PSCs in the fall of 2020, right? And I've been a PSC since, I've been a PSC since 2020. That is enough. If we just sprinkle on a little more information, and it sounds like, and while I was a 1099, I worked these hours and didn't get paid for them. I worked these hours of overtime, didn't get paid. And as a PSC, I also did that. The more info you cannot really, with the tools that I'm using and the workflows that I've created, you can't give me too much information. If you give me a bunch of information, the AI tools, I built a 14-step, I should say not 14, it was a multi-step workflow so that it crawls through all the information you give me, no matter how much you give, it'll parse it out and it'll put it in the sworn statement. And then again, if there's anything that's incorrect, a lot of people just sent me an email and said, hey, Joe, this was incorrect. And I just incorporate that information in, spit out a new workflow. It doesn't create an enormous, I don't want to invite 250 people to redo their entire form from scratch. But since I sent out that email that you're talking about, Naveen, about 30 new people have completed new forms and have, clicked the 1099 box or added information or sent it to me in an email. But I guess what I could have done and what I could still do, but I mean, again, the form's been out there for a month and a half, so it's a little hard to redo, is I could have created the form instead of having a button that says choose one, I could have clicked choose all that apply. I could have done that, but that was just me being, I wasn't doing it in a hurry. I haven't created it. I created this form myself. I didn't pay anybody to do it. And I guess I just chose wrong, but the narrative has fleshed things out. And it's also, by the way, the exercise that I just went through for the week is I've got all of the cases. I've got everything broken down. So everyone who clicked the 1099, you exist on one spreadsheet. Everybody who clicked W-2, you exist on another spreadsheet. And that all those people that you're talking about, all those people that clicked W-2, they're the ones I sent an individual email to say, hey, if there was a time that you were that you were something other than a W-2, let me know. And that, I think, is what inspired folks to fill out new forms.
Okay, so in this case, I'll go ahead and redo the whole thing, and then we'll probably start over in my case, I guess, right?
But it won't be starting over. I mean, all that'll happen is you'll get. I've already created a Form 95 for you. I created a Form 95 for everybody, every single.
Yeah.
So all I'll have to do is create a new sworn statement for you. You won't need a new engagement letter. You won't need anything other than an updated sworn statement. It'll be one signature once the information is updated. If the calculation of damages is different, then I'll change that in the Form 95 and send it to you for your signature as well. But I think your signature, because of the amount of overtime that you calculated, the form the software assumed everybody was misclassified. The software that I created assumed everyone was misclassified. So the calculation of damages should be based on a misclassification. If there were some times that you weren't misclassified, and again, it incorporated all the overtime calculations and all the minimum wage calculations that should have been in there, and it did so on a state basis. Because, by the way, this is how a lot of you will fit in. The federal minimum wage is this just occurred to me 3 seconds ago. The federal minimum wage is $7.50. The state minimum wage is virtually universal in every state and union I'm aware of, except maybe one or two, has a state minimum wage that is 2 or 3 times that number. I know in Colorado, the state minimum wage is 15, and then it varies county to county, but the state-based claim would be at least $15 an hour minimum wage. So and I've been holding the government to the contracted rate of anywhere from 33. The lowest I've seen is 25, and the highest I've seen is $56 an hour. That was a contracted rate that people weren't paid. So the calculation of damages, should be based on you being misclassified. And then when I went back through it and saw that many people had picked the W-2 box, that's why I reached back out to people like you and said, hey, are we absolutely certain? But the forms are already completed. And if I need to amend, and again, I can always amend downward. I can always amend downward. Once the claim is filed, your claim is ready to print and mail. If you click, even if you click W-2, all I got to do is print it and mail it, and I can attach a new sworn statement to it.
Great, thank you so much. And just one last thing. Again, when I was corresponding with some of the PSCs last week, I think some of them were still a little confused about who is misclassified or not. So like whoever I speak to in the future, I'll probably have to say to them that even though you were a PSC, a contractor, and if you got the W-2, then that meant that you're not misclassified, even though you performed the work of an FTE. You did get the W-2, but there were a lot of things that you did not benefit from, being an FTE. But you have to be a 1099 in order to be able to get into the case with the misclassification, right?
That's right. And we kind of fought and lost the fight, the other fight you're talking about. This is one of the only things that was quasi-negative that came out of the Lambro appeal back in 2023 and 24 was one of the arguments that we made back then was that because the government's defense, and this is, again, we're getting into a little bit of law school stuff here, but I want you guys to hear me say it. And again, I'm recording this today also as a room, so I'm going to send you guys, I'm going to put this video out, I'm going to pull it over to YouTube, make it so it's a lot easier to send to your friends. And you can send this video to folks and if they want to listen to me drone on for an hour, then they can hear me explain this as I have to you guys. But one of the things we argued back in 2023 is that the government's defense was these folks can't be government employees because we never appointed them to be government employees. One of my arguments was that there was a constructive appointment, right? Because there was, they were allowed to work in the agency. They gave them CAT cards. They gave you .gov email addresses. They gave you government software and hardware. They gave you, access to the buildings. I mean, you were treated in every way as if you were full-time, except that I should say this, you were allowed to work as if you were a government employee, but you were treated like you were, like you were independent contractors, even though you were in no way independent. You were in no way, by definition, independent. I tried to argue that. The Court of Appeals was like, that's the only, for the purposes of Title V, because, and by the way, it kind of helps you hurt. If you guys were Title V employees, we would be bogged down in an MSPB universe. We'd be in a Merit System Promotion Board going through that administrative process, which could have taken at least as long as we have taken to get where we are. So and that would have been true of any appointed Title V employee. The PSCs aren't Title V employees, right? Because the government chose to not, they'll tell you, well, we just didn't have enough. We weren't authorized to hire more people, but they were authorized to just bring people on as PSCs, and they were authorized to do the government contracting thing. And I've already told the government what they could have done. They could have allowed government contractors to employ you as full-time equivalents, and then you would have at least had union rights. You would have had FLSA rights. You would have had Davis Bacon, and
we would have had more control, and that's what they didn't want.
Yeah, that's right. You would have had the right to unionize, first of all, which would have been a very big deal, right? So anyway, I'm going to make sure, like I said, anybody who lets me know, hey, like you just did, I was a W-2 for this time, and I was a 1099 for this time. We'll still get those FTCA, those 495s out the door. If I have to tweak sworn statements, I can tweak sworn statements. I can make corrections on those sworn statements for the next 6 months. I have plenty of time to make corrections without starting over. I can make corrections to sworn statements. In fact, what should happen is we should get an email from the agencies in the next few months to say, hey, we're investigating Jason's claim or Devrim's claim. Do you have any supporting that? This happened. I do lots of FTCA action unrelated to employment. Every time the VA hospital hurts a veteran, we sue the VA for malpractice, and we do these FTCA actions all the time. And what happens in virtually every instance, 2/3 of the way through the 6-month time frame that they have to investigate the case, we'll get an email that says, hey, we've looked at it, and we need more supporting evidence or more documents. Get us medical records, give us this, give us that. So there's going to be some of that. That's why we've opened up the portal for many of you to be able to drop documents as you have them, as they become available. And that could, like I said, that could be screenshots of text messages that you got from work, or it could be emails you got from work, or it could be contracts. A lot of the Radio Free Europe folks, I'm trying to get a few contracts from that. That's the one that's a little more mysterious to me. That's, I thank Ari for bringing in some of the Radio Free Europe folks, because that was a new addition to the claim that we hadn't done for a while. That's a different, that could be theoretically a different body of law that I have to investigate. So but I'm going to send this video around. I'm going to send this video around. You can send this to your friends. Most of you have emails in your inbox that have that, I drafted that email that has the link that you can check to fill out forms. I can deduplicate that list. If people fill it out more than once, it's easy for me to go through. But again, I don't necessarily deduplicate it. And, if like I said, if you filled out one as a W-2 and one as a 1099, I'm going to use both. All right. All right. I don't see any more hands, and all right. So we got Susie. Susie, what's going on?
Okay. I sent you an email just a few minutes ago, Joe. I need you to call me after this meeting. That's it. That's all I needed to tell you.
Okay.
Okay.
I'll give you a call right after.
Thanks.
All right. All right. Is there anything else? Because it looks like we're at the end of the hour. Again, this video will drop into my inbox here pretty shortly. Jason, what you got?
Sorry, just wishful thinking. Where along the course are we towards eventually getting the resolution we're looking for? I know it can go any way, and the future can be
that's you're asking me to read tea leaves that are a little difficult to read. What I'll tell you from experience is this: it could be, this is one of the reasons I went forward with the FTCA claims. Again, what I'm trying to do is heap as many coals in the government's head as possible, so that they're motivated to settle the case. For the government, the cliff they should be worried about falling off of is the day that I get to discovery and I get the names, addresses, phone numbers, email addresses of the 10,000 other potential litigants that are not in this case yet.
Which is what you said we're going to be getting into mine, right? That's not for the rest of it, though.
That's what I'm hoping to get it. That's why I'm moving to amend the complaint, so that I can open the door to getting additional discovery. Because again, one of the things that Summers is, basically kowtowed to the government is, dismissing anybody that he's keeping, like he did with your case. He just kept it alive long enough to keep me out of the Court of Appeals. But then with the Jordan case, the mistake he made was dismissing people under 54B, so that I could take that up to the Court of Appeals. If the Court of Appeals rules in our favor this year, at the beginning of next year, that should be, if the government has a brain in its head, that should be the beginning of settlement talks, because the risk picture for the government at that stage goes through the roof. Now it's unlimited number of plaintiffs for an unlimited period of time backwards.
So you said about roughly 6 months.
That's what I'm. Yeah. Again, I have no.
Fingers crossed, though. I know I got it.
Court of Appeals is the Court of Appeals. Those guys are building full of 70 and 80-year-olds who can do whatever they want. Ignatius, what is your question?
Just a quick one, Joseph, following up on Jason's question. With regards to Standard Form 95 that you said you just FedEx to the VOA and other agencies, again, what are the timelines? What do you hope would happen from then on?
Well, here that's an excellent question. So that has a baked-in clock. So the government. So that's why I'm very important to emphasize the June 12th number. That starts a 6-month clock for the government. 6 months, if they don't respond, it's a deemed denial, and then I get to file complaints in the U.S. district courts in the however many states I've got. I think I've got probably, I'd have to sort the list, but I'm guessing I've got 10 to 15 states listed here. I break them down, so the Maryland folks would all get filed in Maryland, and it would be filed. That's why I asked you 2 questions, and we'll get clarification before we do all this. But I asked you 2 questions: where do you live now, and where did you live when you worked for the government? Because where you lived when you worked for the government will be the controlling state of where we file. So if you worked in Maryland or Virginia or DC, that's where it'll be filed. Now, I could theoretically file in the U.S. District Court for the District of Columbia and still cover Virginia law and Maryland law, because I can sue the government anywhere it can be reached, and the government can be reached in all 50 states and the Marianas Islands and all of its territories. So that's my right.
Thank you.
So I could theoretically file the whole thing in the U.S. District Court for the District of Columbia, and in the District of Columbia could be charged with looking at all 20 states, and I have 6 months to figure that out. But on the 6-month date in July, August, September, October, November, December. So December 12th, I could, December 13th, I could theoretically file a complaint. We'll take the next 6 months. If it looks like the government's moving toward a settlement and wants to write a check, then we'll take that into consideration. If they seem to be foot dragging and sandbagging, then we'll just file and force their hand in court. Now, when I file that case, they have 60 days to answer. And then, then we're off to regular, we're up to the regular schedule in the federal district court.
Can we be sneaky like them and wait for a holiday and then do that so they get boned like they try to do to us?
Well, we can do whatever. At that point, like we can do whatever we want. But the government has 60 days to answer a complaint, which like no other human, every other human has 28 days, but the government has 60 to answer, and they get an obligatory extension just about every time I file anything against them. All right, guys, if there are no more questions, we're at the end of our hour. I'll go ahead and send this video out here again pretty shortly. And again, if you have any other questions, one thing I want to say for everyone listening to this call and email, if you have a choice, and most of you do, between corresponding with me via email and corresponding with me via either text through Clio, or even preferably the portal in Clio. The portal in Clio has or text in Clio has a virtual 0% chance of getting by me, because it appears on my desktop with a big red dot next to that makes it, and it's specific to your case. So I'm not looking through my inbox for your email address trying to look for the email you sent me. The way the portal works is your communications with me stay in your case, and I can respond back and forth, and we can keep those communications. Now, I'm not going to tell you not to email me. I'm just saying, if you want to make sure you get my attention, I have texted virtually. I think everyone on this call at least once through the system. It's like that 833 number. You use that. If you text me through there, say, hey, Joe, I sent you an email, or Joe, I want to talk to you, or whatever the case might be, or that's a kind of what I call my bat signal. I can't really miss that communication. Whereas the email, you're competing with every spammer in the world who wants my attention because they all believe I have money I don't, and then I want to buy things I don't care about. So that's just kind of my housekeeping thing. Like if you have it, like I said, I know either myself or Carol Lee have texted almost every one of you on one front or another about things. That's a great place. That's also a great place to drop documents. Like I'm looking at some documents from Thomas. He dropped a bunch of stuff here. That's a good way to drop documents. Also, that portal that you guys submitted got. All right, Rochelle, you had another question.
Quickly, you said the 833 number is a good number, correct?
I think that's the one. So I'm gonna do something real quick, just to use you as a guinea pig, Rochelle, and send you a text right now so that you can just kind of see it. It's text messages. I've sent you that. Yeah, this one, your last text from me on that front said thank you. I think it's 833. I mean, it doesn't show me on my end, but here is the text. Okay. 833-223. Yeah, here's a text. It does show me. Here's a text message portal. And then I have the other one I have is the client portal, which is more that shows up in your inbox versus the text message obviously shows up in your phone. Some of you have sent, I can't send you any attachments to the text message service, but some of you have sent me attachments back through the text message service, which is fine. It ends up in the same client portal in the documents tab. So all housekeeping stuff that just makes things cleaner and easier for me to put my arms around 250 of you with your documents.
So I just text you back.
Yep. Yeah, you just sent me back something. Okay, yeah, you just sent me, okay, thanks, right. Yep, that's perfect. That's a great way to communicate, especially if you guys save that on your phone as like WSPC, that's our law firm, WSPC or Joe or whatever you want to do, like that's not going anywhere. It's not going to change. All right, guys. Give your Sunday back to the men on the call who are dads like myself. Happy Father's Day next weekend. I think it's next weekend, right? 21st. I don't know. I'm losing track of time. But
It's next Friday. It's next Sunday. Yep.
Next Sunday. All right. I'll see you guys. I'm going to try to keep this tempo going. Again, if I get head down on it, like I said, but next time I talk to you, the reply brief for the Lamro or for the Lamro/Jordan case should be filed. And then hopefully I'll get an oral argument here soon. All right. Susie, I'll give you a call just as soon as we hang up. All right. Talk to you guys.
Thank you. Great weekend.
Talk soon. Bye-bye.